Stream us live at saga960am.ca.
I'm Norm Murray. This is News Talk Saga 960. Thank you very much for tuning in and joining us. So we're broadcasting live yesterday and also today from KPA Lawyers. They're at 200 Matheson Boulevard West. Suite 100 is where we are, with the beautiful big windows looking out on the sunshine. It's just a feel-good place to be here. Yes, even a law office is a feel-good place to be. Go to kpalawyers.ca if you'd like to find out how to get a consultation with somebody from this great law firm. And they cover it all. I mean, they really do cover all different aspects of law. We're going to be talking family law, but of course they are not limited to just family law. Civil litigation, employment law, defamation law, debt collections, cannabis law, liquor license law, private investigation, business services, charity law, human rights, criminal defense, and on. So they do it all here. Emily Banks covers family law primarily, and Emily earned 2 law degrees from law schools in both Canada and the U.S. She's a graduate of the University of Detroit Mercy, School of Law, Michigan, and Windsor Law School, and she practices in the areas of family law and also criminal defense, currently leading KPA's family law group with experience representing several clients in matters involving child custody and access. Really emotional. You know what I mean? Don't get me, everything is emotional, I suppose, when you're defending yourself or when you are suing somebody or whatever law title or I should say category you're under. But family law, there's something about family law that I think hits home for everybody. Spousal support, matrimonial homes, property division, things like that. And she joins me live in the office. Emily Banks, how are you?
I'm great, thanks.
So glad to have you along. Maybe we'll move that a little bit closer to you if that's okay, Emily. You know what's really nice for me is I get to meet you actually in person. I've spoken to you on the phone several times, but we've never actually spoken in person. So nice to meet you.
Nice to meet you as well.
And you have a beautiful office here. I mean, the whole building I'm talking about, where KPA is, it's very inviting. As inviting as a law office can be, you guys have done a really nice job in making it open and friendly, if you will, so people can relax, because it's a very stressful situation going to see a lawyer, right? You must hear that all the time.
Yeah, it's probably the worst time in people's lives when they have to come see us. So we try to make it as easy as possible for them.
Yeah, you've done a wonderful job. I was joking, not joking, saying maybe we should just set up the radio station here. This is great. I love it here. So, Emily, we're going to be talking today, as you know, about what's called motions to change. And when you first suggested the term to me, I didn't really know what it meant. Maybe you can break that down in family law. What does it mean, motions to change?
So, as you know, things in family are fluid. They continue to change even after you have a court order. Let's say you're 5 years ago, you went to court and you have all of your custody, access, child support, all that stuff sorted out, but everyone's family changes. So in order to change a final order that you received from the court previously, you have to bring what's called a motion to change. Now, this is a full new court application that starts the whole matter again, but it is the only way to change the court order unless there was something wrong with it to begin with.
Wow. Okay. So it sounds like it can take a long time to make this happen too, right?
Yes. So there's timelines of when you can bring them. It has to be at least 6 months after the final order has been made. But it still takes a long time to get a new order set in place. So the amount of time you think it takes to get a first order, it can take the exact same amount of time to get this order for the motion to change as well.
Why is that? Why do you think that is? Why does it have to be 6 months? Why can't it be a month later, for example?
Well, so the main test for a motion to change is that you have to prove that there's a material change in circumstances that occurred from the last order to warrant why there should be a change of the order. So if you think about it, 6 months might not even be very long for something to materially change in your life.
Mm-hmm. I suppose, right? It's very situation specific. I mean, you've seen it all with that. What are the typical motions? What are the most common ones, I suppose, that you've had to address?
The most common motion to change is about support. So support is based for both child support and spousal support is based off your income. So you can think about times things like people now having higher incomes, if they've got promotions or if they lost their job, right? They have a court order, they have to pay child support based on an income of $40,000, and then 5 years later they get fired, and they're still having to pay based off $40,000 income.
Right.
So the only way to get that changed is to bring a motion to change.
So as I see, it's not automatically adjusted in that case. If somebody gets a raise, you know what I mean, or makes a little bit more money, or what have you, doesn't that automatically get adjusted year by year? Isn't there a review?
They're supposed to be.
Oh.
So parties are supposed to sort of work together in order to order to try to do that. But majority of times, especially if there's a really big rift in the family, there's no communication, especially about assets, after the final order is made. So, generally it doesn't get changed without a court order. But people are able to change it themselves if they agree.
Yeah. If they agree to save some money and time and do what's best because there might be other parties involved, such as children, obviously in child support situations, but it doesn't always play out that way. I'm sure there's been many, many examples of where you've thought to yourself, this could have been resolved a long time ago if these people have just sat down like rational human beings and talk it out. Now that's me saying that. I know it's easy for me to say that from the outside looking in. It's always the most comfortable place to be, the outside looking in, right? It's easy to say, oh, well, they should have done this, they should have done that, but it doesn't always play out that way, right?
Correct.
So motions to change. So a motion to change, at least the definition I saw was, it's the name of the court process used to ask a judge to make changes to support in your separation agreement or your court order, and there are family law rules that tell you what is needed at every step in a court case. So even though, like you said, you can have an order in place, it can be changed down the road, and then is it retroactive often as well? I guess that must get negotiated.
It can be. So there are leading cases that say when things can be retroactive or not. The golden rule usually is only going back 3 years from notice of wanting change, but you still have to meet tests to get even that far or further. So, but usually the golden rule is 3 years back.
So is there a statute of limitations on this? Hey, wait a minute, I found out you started making more money 4 years ago or what have you. I think you should have been paying me more all along. What do you think?
So, not really. But that's why they only go back 3 years. So let's say they changed their income 4 years ago, but it's 3 years from the notice of wanting the change. So let's say dad owes child support, is making a lot more money 4 years ago. Mom only finds out. Now brings a motion to change, but so when she serves him with the motion to change, that's his notice that she's asking for more money.
Yeah.
So you can only really go back 3 years from that notice.
Right. Because things, and when there's not an amicable separation and divorce, which is most of the time I would imagine, things can get hidden or conveniently forgotten about. Oh, yeah, I forgot about those raises I've been having the last 2 or 3 or 4 years, right?
Yes, so almost every court order, especially if there's lawyers involved, will have an order that says that both parties need to be exchanging financial disclosure every year.
But what if they don't? Is that against the law? Is there a charge on that?
So it's not against the law in that sense, but it is a breach of your court order. So, you can bring in motions for breaches of the court order, but is it worth it? You have to do a cost-benefit analysis on that. Yeah. But, so that's when, if people are actually exchanging their notice of assessments every year like they're supposed to, as per a court order, then it's easier to decide if you should bring a motion to change or not, because you can see the changes of their income through their notice of assessments.
Mm-hmm. So just the fact that even though months have gone by and there's a motion to change, those motions could be fought also, couldn't they? Which could drag it out even further, no? Exactly.
So because it pretty much starts a whole new court application, you have multiple steps in it as well.
Oh my goodness. Yeah. I'm getting dizzy here, honestly. I can just see how this could go on and on. Thank goodness you're here, Emily. Go ahead. Oh.
Yeah, so you have to still do the case conference and the settlement conference, and then sometimes you can get just a motion heard on it, or other times, depending on how complicated the issue is, a judge will set it down for another trial.
Another trial. Oh, trials. So, trials and tribulations. So really, the point I'm getting at here is, for everybody listening, if you have a family law concern, it may not necessarily even be a separation or a divorce, but if it is, these are the people to talk to at KPA Lawyers. Emily Banks is joining us. We're chatting about motions to change, which is just simply one term. But as you can see, motions to change, how you change a final order in family law, has many branches on the tree. I suppose it can spill over into other things and take a long time. And you need somebody like Emily, or one of the other wonderful people here at KPA Lawyers, to help you stick handle your way through it. Like I just said, oh my goodness, I'm getting dizzy. This is what these people do. They help undizzy you. At least that's what I would need. Somebody to help me just sort of, explain it to me in plain language, like we're doing here, giving everybody practically a free consultation on the radio, really, for this kind of service, motion to change. So, do you have any advice for people, when it comes to, property division and separation and divorce and such, to avoid motions to change? Because that sounds to me like it can only delay people getting back onto living their lives.
So you are capable of coming to agreements after your final order to change the terms of the final order on your own. So let's say the kids are now 10 years older and maybe they don't want to go see one of the parents. If you can agree to it and do a new order yourselves, then you don't need to bring a motion to change. You can do them on consent, so that it can be followed through and have a new court order. Trying to communicate with each other first to see what's the best interest of your children is the easiest way of avoiding that time and cost, but sometimes that's really quite difficult, and that's why we're here to help.
I think I asked you something about this another time. Correct me if I'm wrong. But since we were talking about pets a moment ago, you ever get people who have real legal issues when it comes to their dogs and cats and other pets?
So I'm a pet lover.
Okay, me too, sure.
But unfortunately, the law treats pets as property.
Property, like a car.
Exactly.
Okay.
So it's just, if you're having to leave it up to a judge to decide what to do, it's who's going to get it. There's not going to be an access plan or anything like that.
No access plan?
No access plan for that dog.
I can't visit the dog? Oh, all right.
So that's something that usually if you can try to negotiate that, if it's something that, an animal that's dear to both of you. Yeah. Because the law is going to treat it as property.
I can see that being a sticking point, though, because some people treat their dogs or cats or any of their pets like their children.
Exactly. So you get some people who are quite emotional about it. Yeah.
Real serious about it. And they are members of the family. I believe that, too. But in the eyes of the law, they're a sofa, or right? Who gets it?
Exactly.
As you say. Wow. So, that can be, it's very emotional. Like I said, family law, right at the very beginning, I said that, it's such an emotional thing. We become emotionally attached to things, in our lives sometimes, as well as our pets. And obviously we are emotionally attached to our children, and where there are children involved, motions to change, I'm sure, can come up from time to time. Emily Banks, thank you so much. We're really glad to have you here, and glad to be able to visit you and meet you face to face finally at KPA Lawyers. We'll talk to you again, I hope, in the future, yeah?
Yes, definitely.
Sounds good. We're at KPA Lawyers. Go to kpalawyers.ca. Set up an appointment to see Emily or any of the lawyers here at KPA. We're just scratching the surface. Really, every situation is specific to your situation, and that's why these people are here at 200 Matheson Boulevard West, and that's Suite 100. We're broadcasting live from KPA Lawyers throughout the day today, and we hope you'll stick around. More to talk about in a moment here at News Talk Saga 960. I'm Norm Murray. Don't go away.
Stream us live at saga960am.ca.